Aspen University CJ100, Ethics and Law Enforcement. My name's Andre Rosedale. I'm the instructor for this course, and this is Module 5 discussion question 2, which reads, what if you were a prosecutor charged by the state to prosecute an individual of a crime that could lead to life in prison? Evidence existed that proved the client did not commit the crime, but you were not allowed to include it in the case. How would you deal with this scenario? Since the district attorney is an elected official, how may public opinion influence the prosecutor's decisions about future cases if it is later revealed that the evidence was withheld? I look forward to your response, and I look forward to a good APA reference, even if it's as simple as the textbook. During my master's program, which I also took through Aspen, I was assigned a textbook titled Creating Language Crimes, How Law Enforcement Uses and Misuses Language. And I will cite the reference to that in the description of this video. This text brought forth several cases and examples on how law enforcement has manipulated confessions, the taping of confessions, and the position of wiretaps to cause what a suspect said to favor the law enforcement official's investigation. And these are true stories that are in these books, true investigations. One particular case was Florida versus Jerry Townsend, where the Dade County, Florida police pinned the murders of multiple prostitutes on a mentally weak drifter named Jerry Townsend. That's in chapter 15 of the book. In this investigation, the investigators would question Townsend on tape and then shut off the tape recorder, coach him on how to answer, and then turn the recorder back on for him to repeat what he had been coached. Townsend was convicted of 9 murders based on these coached confessions of a mentally retarded man. Townsend was mentally retarded, and served 22 years in prison before DNA evidence cleared him. In reading the transcripts of the interviews, it is obvious the taped confession on its own is weak and very coached evidence. As a supervisor, is this something you would allow to get past you? As a prosecutor, are these types of shoddy tapes something you would allow as evidence? As a judge, is this the type of evidence you would allow in your courtroom? Let me know what you think about those, and if you're interested, like I said, I'm going to post the reference below. You can look at chapter 15 very specifically and see how you could hear the clicking in the tape as they shut it off, as they would ask the question, shut it off, and turn it back on. I look forward to your response.